I think we can start the session now. Good evening, everyone. Today we have our session on branding and patents, and we have with us Mr. Ayush and Ms. Jasneet. I'll briefly introduce them, and they will be your hosts, your speakers for today. Feel free to ask any questions you have regarding branding and patents. A little bit about Jasneet ma'am. She's co-founder and partner of Just IP. She primarily leads the firm's IPR and corporate practices. She has more than 11 years of experience and also successfully represented clients in high courts, district courts, and various other judicial forums and tribunals. She offers advisory on clients spanning across industries, including media, entertainment houses, software, pharmaceuticals, sports, immigration, on key issues related to intellectual properties, arbitration, and corporate laws. About Mr. Ayush Sharma, he is managing partner at MS Law Partners. He's an advocate on record, Supreme Court, registered patent and trademark attorney with about 17 years of experience in active litigation and ancillary services. He's active litigator, having appeared before Supreme Court of India, High Court, and various tribunals that I really don't know about. NCLAT, NCLT, CESCAT, NCDRC. You have, my first question will be what these are. So welcome aboard, and we're really excited to hear from you. So after Suits and after the goodbye, hearing in real life. Yeah. Sorry for that. Hello, you can play. Can you please mute yourself?
You can mute the participant from your host.
Yeah, host, please act quickly. Keshav, mute them or reject them. Thank you, Keshav, for acting a little late. Not next time, okay? Yeah. Please.
Thank you, Anuradha ji, for the introduction, first of all, and for, organizing this meet also today. So we are here, as you said, we are here to, spread more awareness and information, share some knowledge about branding and patents. So first of all, these two topics on their own are generally very broad topics, but we'll try and fit both of them, at least fundamentals of both of these topics together in one session. And then, of course, there can be a Q&A after this. So I'll start by sharing the screen because we have a small presentation to show. So one second, let me just start the presentation. Okay. I think I'll need access as a host. So if Keshav ji can provide me a host access.
Yes, you are host now.
Yeah. This is the one, right? Right. So, okay. So starting with giving you all a brief example of, general IP that is involved in our day-to-day life, how we can draw examples of brands and, patent technology from day-to-day life. So this is just like a brief illustrative slide. So for instance, you can see that Apple sign as a brand, right? But that same brand is also used for a product in which, there is a registered patent, right? So this is also an example. A phone is also an example of multiple IPs, for instance, in one object. So moving on from here and talking about brands, first of all, which come under the broader spectrum of trademarks. Now, trademarks are basically these distinctive marks that are capable of being represented graphically, in the form of a name or in the form of a logo. It could be a device, it could be an image, it could be letters, it could be anything, right? Anything that is capable of being graphically represented. And that should also have the ability to distinguish the goods and services of a particular merchant from others, as is mentioned in the slide also. Now, these trademarks basically they act in building a valuable brand. They protect businesses and they create an emotional appeal and emotional connect with consumers and customers, right? So this is an overall description of what trademarks are. Moving on to the next slide, branding. So you can see under the topic of branding that there's identity, there's logo, there's design, there is strategy, and there's marketing, right? So branding is basically a combination of all of these things when they work together in tandem to sort of facilitate effective branding, right? So there has to be an identity. When we talk of corporate identity, we talk of some kind of identity that can be associated with a corporate, right? Most of the times we see that there is also a logo or a design attached to it. And all of these things function with a strategy that is oriented with marketing. Now, all of these things are also important because they promote visibility, they promote recognition, they increase business value, they provide an appealing opportunity for investors, and of course, they also provide customer dependability. That is why it is important for any startup, rather any organization, to focus on branding at the very initial stages. Because the way you build on it is how you will look at investors also, you will look at customers also in the future, right? Okay, so we are here to share some effective branding strategies with you that will help startups, sort of clearly understand the kind of strategies that they can have when they are focusing on branding. So this is a multi-branding strategy example, which is mostly relevant for those corporates or companies or startups that have multiple products under the same company, corporate identity. So for instance, Hindustan Unilever Limited has many products, and all of the products come under separate individual brands. So what the company has done is it's developed a multiple branding setup, right? So you can see the examples, you can see the multiple brands that flow from one corporate itself, right? So this is something that the companies can look at when they have different products, different kinds, different ranges, different categories all together, and you can look at a different multiple branding strategy in that case. Okay, coming to family brand or a house mark strategy. So this is an example, as you can see, that there is one house mark, which is the Apple device, okay, which acts like a main so you can say like a main brand or a main mark, right? We call it a house mark, right? And there are sub brands that are developed around it, right? So these are some formative brands that are developed around the house mark. So the house mark stays as is, but there are the other sub branding elements keep changing, right? So how is this relevant? How is this important? This is important because your customers will relate to your house mark, and they will relate that this brand is associated with Apple, right? And wherever this house mark is used in combination with whatever word or whatever label or whatever mark, the customers will instantly be able to identify that this is a brand originating from Apple Inc., right? So this is the importance of developing a house mark strategy. So now moving on to a line extension strategy. So this is mostly got to do with cases where we are working with taglines, for instance, right? So you can see that Coca-Cola branding remains as is, but different products developed around it. So there is Coca-Cola Light, Coca-Cola Zero, Coca-Cola Life, right? So these are like sort of line extension strategies also that can be developed. Okay, this is important in today's world, coming to social media strategy. Now, I've given you two examples. You can see figure number 1 and you can see figure number 2. I'll put this question, say maybe to you, Anuradha ji. Which one of the images looks most declustered to you? Is it figure 1 or figure 2?
I think figure 2, because they have taken color as
Yes.
a brand.
Yes, color also, and absolutely you're right. Figure 2 has a more striking visual appeal in terms of its brand than figure 1. You're right, because they've chosen a singular color theme, which is uniform in their. Yes, absolutely. So the M8 logo is also very clearly reflected at the top of every social media post that they've done, right? So it is coming at the top on every post, and it is clearly visible, and it is uniform and structured, right? So clubbed with the color combination and the entire visual appeal is something which is more striking. Whereas figure number 1 is absolutely clustered. There is no uniform branding strategy adopted, but both are IT solution companies having their social media pages. So same sector companies, but a very different branding approach, which gives a very different visual appeal to customers from the same sector, right? So these are some strategies that one can look at when they are, working on their branding strategies. Now, okay, yes. We are here to also sort of give you some guidance on how you can build a strong trademark for yourself. So when you're looking at identifying or adopting a brand, um, don't look at the first two for sure. Don't look at a generic mark. Something, we say publicly juris, which basically means that it is out there in the public domain. So something like Xerox, for instance. Although Xerox is something which, when it came to the market, it was not something which was common to trade, but it became ultimately so common that every shop owner with a photostat machine would call it a Xerox shop, right? So whenever you're starting into an industry, don't adopt a brand which is already out there in that sector, right? Number 2, don't go in for any descriptive word as a brand, okay? Don't go in for something which gives away the description of your product at the very outset. So yes, so don't go for bicycle rating, for instance, right? Number 3 is suggestive. Now this is a relatively strong brand, so I've given an example saying that Airbus for airplanes, right? So this is something which does not directly give away the description of the product, but yes, it sort of suggests. So this is also like relatively easy to predict. Arbitrary and fanciful are two categories of marks which accord strongest protection, I would say. So arbitrary could be something like Apple being used for electronics. So Apple on its own is a common English word, right? But when it is used for electronics products, then it becomes an arbitrary usage, an arbitrary adoption. So that is why Apple becomes an arbitrary mark. Fanciful is generally used for coined terms that are uh, developed using your own creative intellect. For example, Kodak, Exxon, these are coined terms by companies having no descriptive element, or so they are the most distinguishable, you can say. Okay, now moving on to patents. So this is as far as branding was concerned. We can take Q&As on that later. Moving on to patents quickly. You can see I've given a brief overview of what patents are. They are exclusive rights granted for an invention. It could be a product, it could be a process, Essentially it should be a new way of doing something, providing a new technical solution. These are territorial rights, and the term of a patent is 20 years from the date of filing of the application. We will discuss more on this on about patents. Okay, patentable subject matter. So this is more like an illustrative slide again to give you an idea of what kind of subject matter is patentable. As you can see, number one, any article, apparatus, or machinery or its component also. Number two, any substance, whether living or non-living product, a pharmaceutical product. Number three, any composition of matter of pharma products. And number four, any process, manner, or art of manufacturing other than essential biological process, right? Now, coming to, how now we'll be discussing more about registrability of patents. So I want to just mention one thing here that unlike trademarks, registration of a trademark is not mandatory, although it is important for a company startup to have a branding, in place. But patent, unlike trademarks, is mandatory. So any invention will not be recognized as a patent unless and until it is registered, right? So here, that's why we'll be talking about registration of patents and the process relating to that. Now, there are 4 patent offices in India, in Delhi, Bombay, Calcutta, and Chennai. They are fully automated. More than 90% filing is done online. All database is now digitized. Even communication is done through email and SMS. There is a video conferencing facility available to conduct hearings in case of any examination. There is also an online database public search that can be carried out, which the link is also provided at the end of the slide. I'll show that. So basically, the patent offices in India are working at a very advanced digitized manner where documents are digitized and all communication is now through email. So things are relatively made easy for, you can say, startups and patentees. Okay, this is again a brief outline on jurisdiction of different patent offices to give you an idea. So I think from startups originating from Chandigarh, Punjab, and Haryana, the jurisdiction will essentially lie with Delhi, right? So moving on to the next slide. Okay. Different kinds of patent application. Now here, I think just because we are a little short on time, I'll be discussing just the essential applications. Ordinary application. So an ordinary application is basically, it can be filed if the applicant does not have any priority, is not claiming any priority or any other convention based application. So it is a simple patent application. A convention application, on the other hand, is filed if the applicant is claiming priority from, from an application filed in any convention country, right? But the priority can be claimed only within 12 months of filing of the application in the convention country. Okay, so when we talk of convention countries, we say that there is WIPO, there is a World Intellectual Property Organization, and there are different signatories, there are different countries that are signatories to WIPO, right? So, sorry. So any application filed in any of those signatory companies, one can claim priority from that application within 12 months, okay? Now coming to a PCT-based application. Now what is PCT? PCT is a patent cooperation treaty which was filed, which is like an agreement between with WIPO again, which basically facilitates an easy patent process for international applications, right? And between countries inter se also. So the first step in that is an international PCT, right? So this is a single application where you can designate almost around 140 signatory countries again. And it takes around 31 months from the filing date to enter and request for protection in each of those countries where you designated. Basically, where you want your patent application to have protection, right? Then we come to national phase application. So within those 31 months of the international application, a national application has to be filed in the country that has been designated by the applicant. Now, the national phase application is relatively convenient because most of the formalities and details are taken care of at the time of the international filing. Coming to the divisional application. Now, this is an application that is generally we see in cases where there are more than one invention in a single patent application. So in case that is seen, then the patent office or even at own accord of the patentee, an application can be moved for segregating this inventions into as many applications as the number of inventions are. Okay, coming to patent process in India. So now before there's a detailed chart as far as processing of the application before the patent office, right? But there is a brief process that is to be carried out at your own end before we reach this stage. So I'll briefly describe that. So once you formulated a concept and once you are beyond the incubation stage, right? There is a prior art or a patentability search that is required to be carried out primarily for the purpose of checking novelty, right? So there has to be no conflict with a prior art. So this is something that is carried out once we've incubated the concept and the idea. Now, once we are clear from the prior art search also, and there's no conflict, then we can proceed with drafting of a provisional or a complete application. Now, what is the difference? I'll briefly explain. There are two options available. You can file a provisional application also. But in a provisional application, we provide only brief background and description of the invention, right? After we've filed a provisional application, within 12 months, we have to file the complete application. You can also directly file a complete application. In a complete application, there has to be a detailed background, objects and purpose of the invention, description, detailed claims and abstract, and all relevant figures regarding the invention are required to be mentioned in the complete application, right? So after that step is over and after the filing stage is complete, thereafter this process that is there in front of you sort of takes over. And there is a pre-examination publication. Then there is a request for examination that is required to be moved within 48 months of filing of the application. Now there is an amendment in the patent, there's no amendment, there's a proposed amendment also in the patent rules, which says that this timeline of 48 months be brought down to 31 months. Now, this is only in the amendment stage. This is only in the draft amendment stage. This is yet to be notified. So after this is done, an examination report is issued, which we call an FER, and we are required to submit a response. There may be a subsequent examination report also, to which again, written compliance is required. After the examination stage, there is a hearing stage, and after that, submissions are made, and then there is a decision by the Indian Patent Office to either grant or refuse. And once it is granted, then there is a publication stage, even post-grant. And yes, so this is like, in a nutshell, the entire process of patent registration in India. Okay, now quickly we'll talk about patentability criteria, right? So there are three important elements that are to be kept in mind when we talk of whether a product or process is patentable also or not. So number one, novel. Number two, it has to be inventive. There has to be an inventive step. And number three, some industrial application. Okay, so we'll briefly discuss all of these. So novelty. So it absolutely clear the word itself that it should not have been published anywhere, not even in a seminar or conference, no newspaper, nothing, right? So when we are in that incubation stage also, we generally advise that there is no disclosure of the concept or the idea, or if you're indulging in some kind of a disclosure, make sure that there is an NDA signed between you and that third party. So an NDA is a non-disclosure agreement which protects your your confidential concept and idea, right? Okay, inventive step. Whether the invention has an inventive step or is it too obvious? Okay, so when we talk about this, we have to be sure that an invention has to establish some kind of technical advancement, and there has to be some economic significance attached to it, and it should be non-obvious. Okay, so I'll give a very small example. So when we are talking of an attachment process, for instance, an attachment method, so one can say that two tubes can be welded together also, but a third person can come up with an idea, oh, but we can screw them also, right? So this is a new method, but at the same time, isn't it too obvious to somebody in the same who's working in this field? It is something which is very obvious that you can screw instead of welding, right? So even though it is new, but it is an obvious method. So coming to who can judge whether it is obvious or not? Obvious to a person skilled in the art. So skilled in the art is somebody who is dealing with that industry, right? Who is skilled in that relevant technology, for instance. It could be a postgraduate in the relevant field, although that should not be like a PhD level person. So it has to be someone with little more than basic knowledge of the subject, right? Industrial applicability. It cannot be theoretical, cannot be simply academic. It has to have some kind of practical application. So these are the three important elements to be kept in mind when we talk of patentability of any subject matter. Okay, ending this presentation with some stats for startups, which should give you some kind of encouragement to step up and protect your brands and your patent. In 2016, only 179 applications were filed, patent applications. But in 2021 to 2022, the patent office has seen a major jump with 1,500 applications per year being filed, and a total of by startups. And from 2016 to 22, 7,430 patent applications have been filed only by startups, right? So more and more startups are recognizing the importance of protecting their IP, especially patents and their brands, because all of these factors help you in procuring investment, in developing a strong and dependable customer base as well. So do not ignore these numbers, and do not ignore the importance of not only recognizing but also protecting your branding and your inventions, innovations. Okay, two quick schemes relating to IP and startups. So there was a scheme introduced by IPO for facilitating startups' intellectual property protection. This was basically a scheme introduced to facilitate, provide some kind of financial and legal support to startups in filing and registration of trademarks and patents, right? So what would happen is that facilitators registered with the government would provide these kind of, would provide the legal support, and the financial support would come from the government. So the startups were not required to pay even the official, to pay the legal fees. The second scheme that is there is basically for information and for IT sector startups. Now, any startup registered with any software technology park can avail this scheme for filing an international patent application. So this is only for international patent filing and only for information technology startups registered with a software technology park. So here you get a rebate of up to 15 lakhs depending on the eligibility criteria for international patent filing and registration. I mean, you can look up more about these schemes in case you're interested. This is the link for the patent search of the official IPO, which can help you in conducting the search. And this is the link to the patent filing portal. You can also contact us, and Mr. Ayush Sharma is here, who's an expert, as ma'am has already pointed out, on patent matters. He can take any Q&A you have on this issue. I'm here to help you with any branding related issue if there is. So I think I'll stop sharing the screen for now. Okay, how do we stop the screen?
We have a lot of people in the audience. So any questions now? Thank you so much, Jasneet ji. That was a wonderful presentation. I will take the first question. Meanwhile, everyone, please get up. You can ask your questions. Like we have, you showed a picture. You have given us Apple's example as well. We have one logo and then there is a sub logo, right?
Yes.
So when we are using it, when we are getting a trademark done, only one logo is trademarked. So you're saying that the second product can have a mention of that logo somewhere. Does that validate it?
Okay, so two things. So one thing is that identifying your house mark, as I said, which is your main brand, right? Which is that Apple logo. And the other thing is that using it in combination with a sub brand, for instance. Now, yes, definitely using your main house brand with any sub brand will accord it more brand value, definitely. But it does not mean that your sub brand automatically gets protected because your house mark is registered. If you want to if you want to get a registered right, statutory protection on the sub brand also, then the sub brand with the house mark should also be registered.
And what is the approximate cost for that?
So for startups, there is a 50% rebate in filing a trademark application online. So usually the charges are 9,000, but for startups, the charges are 4,500.
All right.
Yes, for every application filed in a single class, the official charges are 4,500.
Wonderful. Thank you so much. Okay, there is a question I'll read out for you. Oh, it's a long question. Hi, ma'am. I'm a startup based out of Chandigarh itself. My product consists of flashcards for entrance exams like JEE and NEET. The business has been great, and we have recently also onboarded a big company as a client. Flashcards are cards which can fit inside a deck and has all the concise knowledge required for the entrance exams. I wanted to ask if it is possible to file some IP regarding flashcards.
Okay, so there are a combination of things that can be done. Number one, flashcards must be having some kind of title, right? So that title itself can be protected because that title can be the brand of your deck that you're providing. So that title can be registered as a trademark. The entire content of the flashcards can be registered as a copyright, as a literary work. Okay, so this is number two. Number three, if there is some kind of artistic element also involved, if there is some kind of, you can say some kind of design element or some kind of artistic graphics involved that are also originated from the company and they are original work, then that can also be protected as a copyright under the category of artistic work. So three things can be done, but that of course will depend on,
Hi, ma'am. Sorry to disturb. My name is Sahib, and I just posted the question, and basically I wanted to know. I have a trademark registered for the flashcards itself, and the second thing is the second point that you mentioned that we can have a copyright for the content, right? The content and the design, everything. But obviously, with every edition that come up for a subject, like for example, I have chemistry as a subject.
That's
and
true.
I am putting out a flashcard for that. For example, NEET UG is as an entrance exam. I'm putting out flashcards for that. But later, on the other hand, if after 3 months some of the content has to be changed, will the patent remain or will the copyright remain the same?
See what you can do, Sahib, right?
Yes,
Uh,
exactly.
what you can do is you can start at least with every edition of flashcards that you launch. Start putting a copyright sign at least at the bottom of each flashcard. So this is a way in which you can assert your IP, right? Although you are not registering it, but under copyright law, the moment you create a work of art, even if it is literary or it is artistic, the moment you create, you copyright vests in that, right? So you don't need to individually keep registering each work, each edition separately. What you can simply do is you can just use that copyright symbol you must have seen at other places also, and which with each edition just start using that.
I got your point.
That is enough to indicate to any third party or any competitor that you have a copyright in this product.
Okay. For example, we just had a tie-up with Unacademy as a client. Unacademy became our client for the flashcards. They wanted us to print their flashcards for them as well, for the same content that we have in our flashcards. But they just wanted to have them as a brand over the flashcard deck.
Their branding on it.
Yeah, their branding. So we did that, but we were just afraid, like somewhere in future they can copy the content and sound like something like that.
Did
So
you have any agreement with them
yeah, we
regarding?
had a contract. We had a contract, and we shared it with our legal team as well.
Yes.
And they mentioned that everything is fine. They'll not be stealing the content. It is actually mentioned in that no flashcards will be produced from the side of Unacademy in case of anything, and the content will remain of Rancho Chemistry. That is our company.
Right. So what is important in these kind of agreements is that there should be an IP ownership clause, at least in these agreements, which says that even though you are manufacturing and you're printing these flashcards for them, but all rights and IP in the content shall remain with you.
Okay. Okay.
So that tomorrow they cannot go and claim that, you know, they are the owners of the content also.
Okay. Yeah. Thank you. Thank you so much, ma'am, for clearing it out.
No
And it was great talking to you. Thank you so much.
No problem.
Well, we are waiting for more questions.
I just want to say that while we are waiting for more questions, anything you want to add, anything that I missed while I was talking about patents?
No,
I
no,
might
no.
have missed
You
something.
you covered it beautifully, and I think the PPT was concise, and especially for startups to give a brief idea of what actually can be patented, and the examples which you gave, I think, and statistics which are more important for startups to understand why and how this technology and this the things which move forward in the line of startups is very important to protect, because uh, they will realize in couple of years that protecting their IP and raising funds on the basis of their IP is very, very important. And nowadays, the most of, I say, because I deal with a lot with investors. So the most of the investors which look into investment for technical side, the first thing they ask, have you registered a patent in India or elsewhere? And filing of an international patent is also important, because that gives a leverage to a startup in different jurisdiction. As you said, that patent is territorial in nature. If a startup has filed a patent application in India, the startup will have a right in India. But if the startup is such like that, they wish to protect their rights in maybe big markets like US and Europe, they will have to go and file patents in that specific country. And once they have their patent application on foreign foreign countries, that will make their business more lucrative for investors. And so the protection of technology, not only in India, but in other countries, is also very important for startups. And now, as like you have mentioned, programs for startups which help them to file a patent application in foreign countries, and they get benefit of that. So a lot of startups can take benefits of such programs now, and Indian government has done a lot for startups.
Yes.
True. Thank you so much, Ayush ji. There is another question here from Ankur. He's asking, after filing the trademark, can we begin using trademark TM with our logo? After how long do we get registered logo approval?
Okay. Yes, you can start using the TM logo after filing of the application. The symbol R can only be used once you have a registration, not before that. And usually, it takes around 12 to 18 months for a clear application to be registered where there's no objection. These days, there is a bit of a backlog. The Indian Patent Office and Trademarks Registry are hiring more examiners to clear the backlog, the bulk that is there. So there is some kind of a delay, but 12 to 18 months is what you can see if there is no objection and there is no opposition.
One thing I would like to add here, like just a basic the information, that both patents and trademarks now have an expedited process. So if any of the investor really want to raise funds, and they want their technology or a brand to be protected as soon as possible, then they can go ahead with the expedited process. Or naturally, you will have to pay some big amount of official fees, but in that way you can cut down the time period for your patents as well as for a trademark.
I hope that answers your question, Ankur. Anything else you can please ask, and Anju. We'll wait for another, I think, 5 minutes? So please ask questions.
See, I think we can have just a small discussion rather than Q&A, so the startups or the attendees can have better information about patents and trademarks and or other IPs and all.
Yes.
See, as Jasneet has given a wonderful presentation, concising everything which is important for startup in less than half an hour. A couple of things which startups also have to understand. A lot of startups in India usually work in the service sector, but there are incubators, or there are angel networks in different states which provide help to startups on the technical side, which is very, very important now, because a service sector usually tend to cater on the side of a development of a software, or maybe a modification of a software. Fine, that's a great production, and a lot of Indian companies are doing that. But India, there are a couple of Indian startups which we have worked together, and you realize that there is lot of value addition, especially if I talk about solar energy, or we talk about lithium energy with respect to EVs. A lot of startups are working in that area, which has raised a lot of funds. And over a period of time, you will see that the startups which are based on the technical knowledge rather than on the surface knowledge, one, they tend to go forward. The other, they achieve bigger and handsome investment from investors. So startups working on the technical side is very important, and I think I was discussing this with Jasneet with respect to the work, the Angel Network, and then you are doing this, Anuradha, and all. So I think it is commendable to, in a city in Chandigarh and in nearby places that you are helping people, and Angel Network is helping startups to understand the growth and the potential with respect to the IP. And I think we have a question here. I think, Jasneet, that's for you.
Ankur has asked a question.
Yeah.
The question is, for a food and beverage product, if we file a trademark in India, logo and name, which foreign countries is our trademark applicable?
Okay, so see, trademark is a territorial right. You get protection only for India. So if again in trademark also, like patents, there is a provision for a PCT. In trademarks also, there is a provision in which you can file an international application under Madrid Protocol, right? So again, around 180 countries are signatories to that agreement, which those countries you can designate where all you want to get your trademark protected. But for that, you have to first file an application in India. And then basis that application, you can designate those countries. You can also go and directly file a trademark application in those countries where you wish to get your brand protected. But in India, if you're getting a registration, then that is protecting you only in India.
He's thanking you for the answer.
Okay, I hope that clarified. Yeah.
We can continue if we can get more knowledge, it'll be great.
Yeah, am I audible? I
Yes,
don't know if
yes,
I.
Govind, you are.
So, मैं ना गाड़ी चला रहा हूँ, so excuse me for that, but I do have a question. So, ma'am, I run a gaming company as well, and we create characters time to time, which might get famous when this game gets a lot of installs. So, what happens in case we make a game character that is of probably some hero, but like let's suppose I like a character whose name is, if you have seen this web series Panchayat, right? उसमें सचिव है, तो if I create a छोटा सचिव kind of character for a gaming a gaming app, so can that be protected, or will I be violating some rights in case I do create something like that?
Yes, see, I mean, okay, see, one basic concept of IP is that there has to be no third party conflict, right? Whether it is trademarks, whether it is copyright, whether it is patent, designs, anything, there can't be a conflict with any third person's original work or creation or anything that comes from their creative mind, right? So even if it is, for instance, the name, you can develop a different character altogether, which has different characteristics, which doesn't look like the character that you're describing, but you give it the same name. Okay, that also may be a conflict. Okay, second is you give it a different name, but you keep the characteristics same, which make it so apparent that you've copied the character but you've given it a different name, right? So that is also a conflict. So these are things you have to bear in mind. And of course, as a particular entity's character grows and becomes popular, the more, number one, they will be interested in enforcing their rights on the character, and number two, the more apparent the imitation will be.
Just to add one more point, see nowadays, because of such OTTs and all the web series and all, and social media and other things, if you see the kind of protection they try to keep with them under the copyright, that would cover any artistic caricature, maybe artistic drawings, or a caricature, or a 3D model, or a 2D model. Now people have started realizing the value of this. Initially, a lot of people were not aware about maybe caricature, or a 3D model, or a 2D model, or other artistic drawings and all. But over a period of time, maybe evolvement of law and evolvement of technology, all the companies have realized that this can also be done by some third party to reap benefits of their characters. So like what Jasneet is saying, that even in other forms of maybe web series or OTT or a gaming or 3D model, now they try to protect each and every form of their character, maybe in any form. So you might be in difficulty if you make it very similar to, as Jasneet has said, very similar to the character already made by somebody else.
And on the other hand, if there is a new character altogether that you have developed and you want to protect it, if you see it getting bigger and you want to protect it, then file a trademark application for its name, file a copyright application describing the characteristics, file a copyright application for the artistic character structure. So, these are different ways in which you can protect your character. But we've given you both sides. We hope that it clarifies both your.
Yeah, that was very helpful. Thank you so much. And I was not.
Okay, no problem, Govind.
So we have one more question here, in fact, two. I'll ask the first one. Share some views on IP monetization.
Okay, Ayush sir, you.
See, IP monetization is one thing which, especially for startups, is very important. Because like I was giving an example of service industry and a technical, that's why I was giving an example. Once investors come to you and they say that, especially patents, if you have a patent on a technical, so they think and they know that you are technically sound and you have a registered patent which is granted by patent office, Indian patent office, so it has a value. Especially the patent office has looked into it, examined it and found out that this technology is worth patenting. So once the investors come or a third party comes to you that, okay, fine, you have a patent, you want to, whether you want to monetize it or not, there are a couple of agreements. It's basically more of a contractual in nature. There are a couple of agreements which you can enter into. Either you can give a license to third party, like, okay, fine, you remain the owner of a patent, but you license to third party for use the technology for some time or maybe for some area. Like, let's say you have registered patent in India and in US. You may license your US patent to some XYZ, and you license your Indian patent to ABC, and reap benefits from both. You take royalty. The other thing is that you can assign the patent, that is sell. Once fine, you said, okay, fine, I've got a patent, my interest is something else. Somebody is coming, okay, fine, for so and so amount, I will sell this patent to you. Like I give a very big example. I think a lot of people would remember an email called Hotmail, right? Now, so the Hotmail was not made or invented by the company which actually run the Hotmail. It was created by an Indian person. So that Indian guy sold off all its right in Hotmail to the company. He said, I'm getting more money. I will use this money to develop something else. So that is one way to develop and to monetize your IP. He made it, he registered it, he sold off for a good fortune to a company, he moved on and he used that money to develop something else. Other examples are, I'll give you an example of you have a very big patentees like Samsung and all. They don't sell their patents. They don't sell their technology. They license their technology to third parties and make benefits of that. So monetization is done through contracts. You have to see what will bring you more benefits and all.
The last question. Yeah, Ankur, you want to ask question? Okay, the question is, if we have filed a trademark application and say 6 months later someone else has copied our brand logo or name, what is the course of action in this situation and how much time or cost it will be?
Okay, see, this needs some more clarity. So there can be 2-3 situations here. in India, generally, we have a first to use concept rather than first to file. Unlike, say, for instance, in the US, there is a first to file concept. But in India, a prior user of a trademark is protected more than, um, an applicant who's filed a trademark application. So an application can be filed on user basis also and on proposed to be used basis, right? So it is very important to see who is the first person who has used. So in your case, if you have filed the trademark application, but there is a third party that has copied your trademark and is using it. So two scenarios can happen, that they are using it or they have also filed a similar application. Okay. So in the case where they are using it, then we will have to see whether there is some kind of dishonest adoption or not, right? Because if you filed a trademark application, then whether, even if you're not using it, whether it was in the knowledge, whether it is an identical trademark, or if your trademark is also descriptive, or it is, a coined term. Some terms are coined where it is difficult to imagine that, any third person can also coin the same term, right? So if it is that kind of a trademark, then it is easier to establish dishonest adoption, right? And it is easier to enforce your rights. But if you say that, for instance, let's say kitchen roll, my brand is kitchen roll, and I filed an application for registration of kitchen roll, and tomorrow I say 6 months later somebody has also started using kitchen roll, then I can't stop that person, because kitchen roll is so descriptive, it is so common to trade, right? So these are all factors we have to see when we are looking at a case like this. So it's very difficult to really explain. What you can do is, you can also send an email, you can share more details, and then maybe once we've seen everything, we can advise you better.
Perfect. Thank you so much. Thank you, Jasneet ji, Ayush ji, for being here, sparing your time, and helping our startups here. We would follow up if there are any follow-up questions you have shared.
Just write. Yeah, just
Yeah,
write.
yeah. So you've shared your contact details, and otherwise you can write it on the group. We will be very happy to assist you there. Just IP is Shivalik View, so everybody knows Sector 17 now.
Yes. Thank you, Anuradha ji, for organizing this. It's great, the work that you're doing for the startup ecosystem in Punjab. Congratulations to you.
Thank you.
Yes, thank you, Ms. Anuradha. And Jasneet has said a good things about your work while I was discussing with this presentation. Thank you so much. And thank you everybody for this meeting.
Pleasure. Thank you.
Thank you. Bye.
Thank
Bye.
you.